Thank you so much for staying here on the AM show. I'm Bernice Abubedulansa, and my colleague Richard Kadunyako wraps it all up beautifully on what exactly transpired in court leading to that sentencing of Mr. Ato Essien. But we've got a lot more information to share with you on that, and we'll be rolling that on the screen. And then we will be hearing from lawyer Pencil, who is a private legal practitioner, on the case so far. So, Mr. Ato Essien was convicted of stealing over 90 million cedis of the Bank of Ghana's liquidity support to the now defunct Capital Bank. Now, his inability to fully pay the said amount back to the state after agreeing to do so despite being afforded the opportunity led to this 15-year sentence. William Ato Essien, Reverend Fitzgerald Donko and Tetenete, a former managing director of MC Management Service owned by Mr. Essien, were charged with 23 counts of conspiracy, stealing from the 620 million cedi liquidity support given to the bank by the Bank of Ghana to enable it service its maturing debt. The accused persons, according to the prosecution, opened various bank accounts with Capital Bank through which the 620 million cedi Bank of Ghana liquidity support was transferred, while others were carried in jeweled bags to Ato Essien. Now, on the payment of 90 million cedis to the state, Mr. Ato Essien had earlier paid some 30 million cedis upfront in December 2022, and he made additional payments of some 5 million cedis, I beg your pardon, bringing the total payment to 35 million cedis. In May 2023, he was given up until July 4, 2023 to liquidate his assets and pay the state the remaining 55 million cedis. The deadline elapsed without any payments made. Let's now speak to lawyer Kweku Pencil for more on this. Good morning to you, lawyer. It's a pleasure to have you here on the show. So the big question I've seen being asked on social media, especially for persons who are wondering what next, is that, is there any lifeline for Mr. Ato Essien in all of this?
Hello?
Hello, lawyer. Can you hear me?
Hello, can you hear me?
Yes, I can. Can you hear me?
I can hear you clearly.
Right, great. I was asking, there are many people...
I can hear you clearly.
There are many people wondering...
Let me add my sweet beauty.
Thanks for the kind words. The question I have seen, especially on social media, is that the end for Ato Essien? Does he have an opportunity to appeal after all the lifelines given him?
No. I have looked at the law. It's Act 1079, I think. That amended the criminal procedure code and introduced this plea bargaining of the civil trial proceedings or procedure called terms of settlement that culminates in a consent judgment. Under the Act, a person who enters into a plea bargaining starts by admitting his liability. And once you admit liability, the court has got no further duty, no further burden, no further whatever to continue with the trial of the matter. So you are convicted on your plea, your own plea, that dispenses with any further investigation. That's the first point. It's also explicit that once you accept a plea bargain, you lose your right to appeal against the judgment. Because the essence of a plea bargain, like a consent judgment, is that it cannot be set aside. You entered willingly and freely with on your own volition, with the help of your lawyer. And indeed, before a judge convicts you, or rather, yes, accept the plea bargaining by accepting your conviction, the judge is supposed to take you on oath to make you admit these essential elements of the plea bargaining agreement. So the answer to that question is a flat no.
So this means that he is going to jail for 15 years.
Hello?
Right. So I'm just saying that. So, I mean, it is what it is.
It is.
Right.
The law only provides that a person may apply to set.
It appears we're having a challenge with lawyer Paintel's line, sadly. We will try to rectify that and get his thoughts on this, and also what the law says, what the legal perspective is. Hopefully we'll be able to do that. If we're unable to get him on a stable line via Zoom, we'll try and reach him via phone. But if you just joined us this morning, we are just trying to understand what the stakes are for Mr. Ato Essien, the founder of defunct Capital Bank, who has been handed a 15-year jail term. As lawyer Paintel was explaining, according to some amendments made, once you enter a plea bargain, you have lost your right to appeal a sentence if you fail to honor your side of the bargain. So he was just about answering beyond the appeal if there was anything that could be done, even if it's politically, because we get that sometimes when, the executive interventions to some of these sentences. And so if we're able to reach lawyer Paintel on a more stable line, we'll be able to hear him. Thankfully, he's back. Lawyer Paintel, so you were just, you were saying something when we lost you there.
Yes. What I'm saying is, the law only provides for the option of applying to set aside the judgment on any ground. It could be of fraud, it could be of deceit, it could be of incapacity, it could be of unsound mind, it could be anything that can vitiate the agreement. In other words, the argument then will be that at all material times that the person entered into the plea bargain agreement, either was not compos mentis, in the sense that he did not appreciate what he did, or that he was induced by something beyond what we all saw on the surface. But those are very, 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 it's a very thin line for anybody to use to set aside a judgment of a court. Of course, the only other element, the only other option, the only other avenue that's open to him is executive intervention by the president prerogative of mercy. The president has power without answering to anybody to decide to pardon anybody of any criminal offense. And in Ghana, that is a very common part for high exposed public individuals. The president has been using it, even though not frequently. But as a matter of law, these are the only two options open to Essien. Nothing beyond that.
Interesting.
Yes.
I'm just wondering, in explaining to us the events that led to yesterday's sentencing, our correspondent spoke about a certain argument that lawyers for Mr. Ato Essien raised about he trying to put up some property locally and internationally, putting them up for sale. And we know how sometimes these things are. They may not be a ready buyer and all those kind of things. Couldn't that have been a strong argument to advance by his lawyers?
No, you see, the thing about plea bargain agreement is that, I think even the first thing that I should tell the press is that a plea bargain agreement is essentially a public document. And the Attorney General is not doing all of us good service by not making available a copy of the plea bargain agreement, because like the four corners of an agreement, and the judge himself cannot go outside it except in sentencing. Even the sentence itself is supposed to be part of the plea bargain agreement. They can agree on a range of sentences. And it's only when the plea bargain agreement does not contain a range of sentences that the judge is given a discretion to impose a sentence of his own. So the first point is the Attorney General himself is not doing us favor, or rather is not helping us at all by not making a copy of the agreement available to us. That's the first point. So what is happening is that they are allowing all of us to speculate. So if it was not in agreement, I'm talking about what the lawyer said. If it was not in agreement, if there was not an option for Ato Essien to be given time and extension of time to cater for all this kind of situation, it is out and out and out. And it has no bearing whatsoever and cannot in any way influence the judge. So it's all about what was in the the plea bargain agreement. But from my understanding of the plea bargain agreement, Ato Essien was given a deadline, and that deadline has passed. And once the deadline passes, I think the judge has been magnanimous because there's even no time element to what they are proposing. So from my understanding and upon a proper reading of the law, does not even appear to be an option for him to continue the payment, to get any concession whatsoever. Unless, of course, we see the plea bargain agreement. But if it is not in the plea bargain agreement, if it brings another 60 million, Ghana as a country will be thankful to him. But it cannot influence the judgment that the judge has passed, which is final.
Interesting. So your general impression of what this means, even for the entire process of the banking sector cleanup, and the kind of signal it sends into the financial space about how things are done, what the impact of this sentencing is.
Yeah, I think it's good. I think it's good for the banking sector because see in Ghana, everybody takes the country for granted. On the admitted facts, if you take money that's made available to a bank for use to turn the bank around, if individuals can carry it in jute bags and wherever, and that tallies with, all the reforms that a body called the Bank of Ghana did in the banking sector, including all the non-financial bank institutions. You know what? People are living, all the people. There were all kinds of attempts or whatever. Ghana, we were in the present crisis we are because the government bailed all these people out. But the owners of these businesses, they are living flamboyant lifestyle. Now, Essien is talking about properties outside Ghana. Whose money did he use to buy those properties? It does not apply to Essien alone. It applies to the whole banking sector, all the people who took all our monies. And you know what? Come on, what has happened? Essien is just one. I heard the Deputy Attorney General talking about 5 others. What about all the non-banking financial institutions, the loans and saving companies, all the money that they took? And the Ghana government has paid each one of the investors. So how do we retrieve that money? If these people like Essien have properties outside and inside Ghana, they have invested these monies in things, and everybody has turned a blind eye to what's going on. So it's about how the Attorney General can revamp the prosecution if the whole idea is to ensure either that we are getting the monies which these people took, or the corporates must follow and of their conduct. That's the way to run a country. That's the way to run it. That's my view of this matter.
Now, let's stay within the legal space, but move on to another matter, which has to do with the OSP's request for the Chief Justice to recuse and remove His Lordship Justice Edward Chum from all cases involving the OSP pending before him. Now, the request is grounded on the OSP's belief that Justice Edward Chum appears to be highly prejudiced against the OSP and the person of the Special Prosecutor. Consequently, as it stands, the OSP will not and cannot be reasonably expected to be parties to proceedings before the said judge. And I know that you had thoughts to share on this earlier, but let's start off this way. The OSP is concerned about this particular judge. First off, this petition that the OSP has sent to the Chief Justice, would you call it normal procedure? Has the OSP, jumped certain steps, or it's within his rights to go straight to the Chief Justice to ask for this judge to be recused?
I'm totally unimpressed and embarrassed by what the OSP has done, for the reason that if you go a case before a judge need not be friend to anybody, need not be friendly to anybody. A judge can be whatever he wants to be, as law is that it is ability to dispense justice without fear or favor.
Too bad. Lawyer Pento's line is breaking again. We had a bit of a stable connection with him. I don't know what's causing the break now, but we will try and establish a better line. But what we're discussing now, we've moved on from the Ato Essien case to the OSP petitioning the Chief Justice for the removal of Justice Edward Chum from all cases involving the OSP pending before him. That also appears to be a challenge from some other legal people I've heard from. The question is whether it is even proper for one judge to have so many cases involving one particular party before him. Hopefully we'll be able to raise Lawyer Pento for his thoughts on that. I don't know what your thoughts are on that particular matter, but we know that there has been an ensuing case between the OSP and Madame Cecilia Dapa. That judge is sitting on that particular case. I'm told Lawyer Pento is back. Sorry, lawyer. You were saying that you were unimpressed about the decision of the OSP.
Yes. Because the first point of action, tell him exactly, you know what, it just a case of prejudice or bias against a judge is a very serious one. I mean, and it must not be made lightly. It must be supported with evidence, hard evidence, concrete evidence, allegations of facts supported, particulars of those facts. Then you bring it before that very judge, because there are two parties before that judge. And you give the opportunity to the other party also to respond to the allegation. Obviously, the judge himself cannot, speak in his own whatever. But there are two parties before the court. So the idea is for the two parties to speak to it. I'm giving you an example of what transpired about 2 weeks in America. You remember that Trump and his people, his lawyers, they looked, what do you call it? A recuse application against the judge who was sitting on one of his cases, Judge Chuckton or so, that black lady, if you remember, the judge. They went before her and she threw out the application because, see, we are guiding everything that we do. So the mere fact that you come up and claim the judge is biased against you, it's not evidence of your allegation. So that is the first point of, my view, that's the first issue I've.
Hello, Lawyer Pento. Hello, Lawyer Pento.
Hello.
Yes, sorry we lost you. I'm really sorry about.
A complaint. This is poor service. So we'll talk about one problem. Next time, let us talk about how these telecom services, companies are treating us as Ghanaians. But to go back to my point, that's the first point. In the second point, can you hear me?
I can.
Hello?
I can absolutely hear you, sir.
The second point is that, you're very right, if you come before a judge, judges make decisions based on the facts before them, the evidence before them, as well as the law, how the law applies to the facts and the evidence. So every little thing that a judge is founded on the third element. Therefore, if a judge makes all
I'm extremely sorry about the quality of our lines this morning. As you heard Lawyer Pencil suggest, it's a problem whenever it rains. It's quite rainy in some parts of Accra this morning, and as you know the norm, the lines go bad, the internet drops, and so we're having a challenge with that line. We'll try and raise him on the phone line. Hopefully that will be better. But that was Lawyer Kweku Pencil. Earlier you heard him talk about the case involving Mr. Ato Essien. He's been handed a 15-year sentence. I'm told Lawyer Pencil is on phone now. I'm so sorry we have to go through this, Lawyer Pencil. But you were concluding on your second point about the OSP's decision to petition the Chief Justice for His Lordship Justice Edward Chum to be removed from all cases involving the OSP pending before him.
Yes. So the second point, as I said, was that if you believe that a judge is giving a decision which is not in accordance with law and laid down principles of law, you lodge an appeal against his decision, and it goes on appeal, and it got three judges or the three wise men who have an opportunity to take a decision whether they agree with the judge, they don't agree with the judge. So like I said, a judge did not be friendly to you. A judge did not make concessions to you. The fact that a judge has ruled once against you does not mean that he's obliged to grant you. It's not that kind of game. A judge on the basis of the law can decide to remove, and what do you call it, dismiss as many applications as he finds improper. And if you disagree with him, that is not a reason to say he's biased. No, that's not the law. But to comment about the petition to the Chief Justice, my problem with the petition to Chief Justice Essential, which is my third point, is that the Chief Justice performs an administrative duty. Administrative duty only. He does not sit as a judge over issues of transfer of cases from one judge to the other judge. It's administrative duty that the Chief Justice has got, and what it means is that if you've got reason to believe, any sufficient reason that requires that a matter must be moved, maybe the judge is sick, maybe the judge is on leave, maybe, and those are the administrative things. That you go to the Chief Justice and require or plead with the Chief Justice that you should take this case to this court, or not to this court, like you should transfer the case to another court so that for the expeditious hearing and so forth and so on. But you know, when you take an application of this nature, a petition of this nature to the Chief Justice, you are essentially inviting the Chief Justice to what you call exercise a judicial function, which is unfortunate. Because what must he do? You mean the Chief Justice to call the judge, to question the judge, or should, what is the Chief Justice supposed to do in a matter that affects the delivery of justice by a judge who is sitting? And that's the embarrassing part that I'm talking about. So even though the Chief Justice has got power and authority to transfer cases from one judge to the other, my point is, it is not for purposes of determining the conduct of the judge who sat over the matter. Now what's going to happen is that if the Chief Justice accedes to that request and the matter gets transferred to another judge, what's then going to happen? Then the judge is going to look over his shoulder. And what are we talking about? You know, so some of the things that we do, even though we all aim and intend to reach what they call certain purposes for justice and so forth and so on, I think that the way that the OSC is carrying on, and even to the extent that you say all the cases, how can it be? Some of the cases are put for purposes, let me tell you what, for purposes of ensuring a consistency. Cases of like nature are normally put before as one judge. The idea is
answering that question, because I was just going to ask if that could also be one of the reasons why the OSP is raising concerns.
But like I'm saying, if that judge, one judge decides to dismiss all cases you bring before him on the basis of the law, you appeal. Because you always have an opportunity to appeal against any decision of a court. You don't gauge a judge's attitude to your cases and on that basis classify that attitude as biased when you don't have the facts and the evidence to support it. Because that is letter that he puts out. There's no iota, there is no atom, there is nothing about fact or evidence in support of that allegation. So it remains a bare allegation. But the point I'm making is that when a case is before a judge, administratively, cases of like nature are normally placed before one judge, either administratively or by the parties in what we call consolidation. In other words, if you've got cases of like nature which are pending in different courts, the danger is that different judges they come to different conclusions on the same or similar facts. And to avoid that kind of administration of justice, it is usually, of good discipline that all those matters of like nature will be placed before one judge. That is, it is the norm in the judicial service. And where it is not done administratively, the lawyers involved in that case will normally apply for the suit to be consolidated. So therefore, I wouldn't know if he wants to make that bandwagon movement from one judge, then all of them will go to another judge, or he's saying that the cases will be split before different judges. That one is related to administration of justice, which may affect the justice in the case at the end of it. But I've told you my view about what the OSP has done, which is he should have gone to that judge, or he should have appealed. Invoking the power of the Chief Justice in this kind of circumstances, in my view, is unfortunate. That's my view.
There's an option, isn't it?
Yeah, that's the point I'm making.
And so, I get your point about, he could have gone to the judge, but obviously this is somebody he thinks is biased towards him, and so...
But let me tell you something. One basic rule, what we call the rules of natural justice, there are two. The first one, or the one of them, is the nemo juris in consensual principle, which is no judge must be a judge, no man must be a judge in his own court. The twin of that principle is what we call the odi autem partem rule of natural justice, which means that give the party a hearing. So if you claim that a judge is being unfair to you, and you cannot go before that judge and tell him to his face that he's being unfair to you, and you have the evidence to prove that unfairness or bias, then you yourself, you're not being fair to the judge. That's the first rule. They say that God even did not condemn Adam before, without giving him a hearing. So that's why we call natural justice. That rule of evidence, that rule is one that is basic. That before you condemn me to somebody, give me an opportunity to respond. And that's why he owed the judge a duty to go and face him fairly. I never saw any judge who picked the cane and cane any judge in his court, any lawyer in his court. And like I'm saying, come on. That's the way to go about it. You can't say that the judge is so hostile that he cannot even hear you. Go ahead and tell the judge to his face. And we do it. You can't be a lawyer and be a coward, or be a lawyer and not be of bold spirit, or be a lawyer without the ability to confront fairly anybody that you've got a case against, anybody that you think is not dispensing justice in accordance with law. That is the oath we take as lawyers. That is the oath judges themselves take to dispense justice. So it complements one another. So that is my view on the subject. And I say he has not been fair to the judge by doing what he did.
So much, Lawyer Paintel. I appreciate your time here on the AM show. That's Lawyer Kweku Paintel sharing his thoughts with us on the OSP's petition to the Chief Justice for His Lordship Justice Edward Chum to be removed from all cases involving the OSP pending before him. The OSP believes that Justice Edward Chum appears to be highly prejudiced against the OSP, thus the office of the Special Prosecutor and the person of the Special Prosecutor. Much earlier, we touched on the Ato Essien case. You're watching the AM show. We've got a lot more for you, including the NSMQ. This morning's quiz will be featuring St. Augustine's College, St. Peter's SHS, and Ibri Girls. Do stay for that.